Good afternoon, everyone. My name is Peter Neufeld. I am a partner at Wagner Sidlowski and the co-chair of this Lunch and Learn series titled Strategies, Advice, and the Elderly, along with my new co-chair, Brad Phillips. So hi, Brad. Both Brad and I will also be presenting today, along with Peter Askew. And the subtopic that we're going to be speaking about today is strategies when dealing with the elderly's rogue children. Rogue is a specific term we say throughout this presentation, but effectively we're meaning a decision maker who is not following their obligations under the Substitute Decisions Act and not uh, conducting themselves in accordance with the incapable person's best interests. A paper was prepared by Jason Thacker and myself in advance of today's seminar on this topic, and a link to that paper can be found in the Zoom chat. The certificate of attendance will also be posted in the chat momentarily for you to download to confirm that you were here and you attended today's seminar. The seminar has also been approved by LawPro for the risk management credit, and it's eligible for a $50 credit claim. That's free money, so feel free to take advantage of that. And you can also refer to the document posted in the chat for details. Of course, as always, a big thank you to our sponsors, Scotia Wealth Management, the Benin Brith, Concentra Trust, Weir Folds, Donovan Kochman, LLP, and Torkin Mains, LLP. This event is complimentary because of them. Also, as always, a few housekeeping notes. Please have your microphones muted at all times unless you are asking questions at the end of the presentations, after which we ask that you mute yourself again. Please also note that this seminar is being recorded, so anything that you say will be recorded. As I mentioned, we've got three presenters today, myself, Brad Phillips, and Peter Askew. Both Brad and I are partners at Wagner Sidlowski, and we both practice in estate and commercial litigation. Peter Askew is a partner at Miller Thompson in the trusts and estate litigation group. So let's get on with the presentation today. We have broken down this issue of rogue caregivers into three sections, and these are practical situations that, in our experience, litigators come across, unfortunately, more than a couple times. And we talk about the strategies for dealing with rogue caregivers, how to seek restitution, how to seek deterrence in those specific examples. So there's three topics, and each presenter will be dealing with one topic. The first that Brad Phillips will, or that Peter Askew will deal with rather, is a financial abuse, that effectively that there is a caregiver that is taking funds from the incapable person, that is using the incapable person's money for their own benefit. I will then talk about situations where a rogue caregiver who is often living with the incapable person refuses to facilitate access to that incapable person. Friends and family want to see the elderly person, but they're simply being barred from doing so. And then Brad Phillips will finish off the presentation talking about situations where, again, the rogue caregiver is actually living with this incapable person, but they themselves refuse to leave. They are living often with the incapable person at the incapable person's home, typically rent-free, and they don't want to leave. And so Brad is going to be discussing that. So let's start off with the seminar. Mr. Askew, you can go ahead.
Thanks, Peter. And thank you to Brad and to all the other sponsors of today's event for having me. And good afternoon to everyone who's logged in. As Peter mentioned, I practice in the area of estates litigation, and I have been doing so for a number of years now. So I have had occasion to deal with instances where a family member may be engaging in financial abuse of an elderly parent or other relative, and it can be a difficult situation for clients to deal with. I've structured my comments today sort of in two phases. Um, when faced with a situation where there may be financial abuse, I first want to speak about how to address that on an immediate basis to potentially stop it, what strategies might be employed in that regard. And secondly, I want to talk about how to pursue the individual who's engaging in the misconduct to potentially recover any losses, misappropriated funds, and so on. So beginning with how to stop this abuse that may be occurring. Um, if the financial abuser is an attorney for property, then the first avenue to address their conduct may be to commence proceedings seeking their removal and replacement with a guardian of property. That could be another family member or it could be an independent professional. I will qualify this or provide the following comment on that remedy. It's not one to be taken lightly. Replacing an attorney with a guardian is often seen as an option of last resort by the courts. Generally, courts are loath to interfere with the expressed will of a grantor of a power of attorney. But with that being said, if there is evidence that can be demonstrated in terms of financial abuse, then it may be an option to consider. The test for removing an attorney for property was outlined in Teffer and Schaefer's, where the court found that there must be strong and compelling evidence of misconduct or neglect on the part of the attorney before a court ignores the clear wishes of the donor, provided the evidence establishes that the donor was capable of granting the proper power of attorney. The court will also investigate whether the best interests of the incapable person are served by the attorney. I would note that the standard for attorney's conduct is not perfection, and so clients ought to pay heed to the comment and the finding by the court in Teffer that there must be clear and compelling evidence of misconduct. And so that is part of the initial advice to the client in terms of gathering evidence that might meet that threshold and advising them on whether they have enough to potentially succeed on that remedy if it's going to be a contested application. The court's reluctance to remove an attorney is compounded by the fact that sections 22 sub 3 and 55 sub 2 of the Substitute Decisions Act require that a court shall not appoint a guardian if an alternative course that is less restrictive of the person's decision-making rights is available. So that's also something to be mindful of. Um, Guardianship applications could be a whole uh, seminar in and of themselves. I won't spend too much time on that, but certainly one one option to consider in terms of addressing financial abuse on an immediate basis. As part of such an application, you might consider moving for injunctive relief or freezing orders to prevent dissipation of the elderly individual's assets at the hands of this family member or other individual. If your client is the attorney for property or a co-attorney for property, it may be possible to, depending on the facts of the situation and the terms of the power of attorney document, it may be possible for the client to take steps without commencing court proceedings to secure assets under authority of the power of attorney, securing bank accounts, alerting the bank to potential financial misconduct and so on. That can be a measure that can be in some instances can be taken directly by the client to protect their elderly family members' assets. Now, in terms of pursuing this individual, that may be the next step. You may consider seeking instructions to do it in conjunction with some of the steps that I've just talked about, whether it be a guardianship application or otherwise. The first avenue to potentially uh, pursue recovery of funds that have been misappropriated, in my view, is often to seek to compel that individual to pass their accounts if there's evidence that they've acted um, in a capacity where they were managing the elderly family member's finances. The Substitute Decisions Act permits any person to bring an application to compel an attorney to pass his accounts with leave of the court. However, the court must be convinced of the following before granting leave. Number one, that the person or persons seeking leave have a genuine interest in the grantor's welfare. And number two, uh, on that basis, a court hearing the application rather may order the attorney or guardian to pass his or her accounts. It's a discretionary remedy. So the courts will often, in my experience, look to all of the relevant circumstances and make an order that it views to be just in the circumstances and on the facts of that particular case. Leave may be refused where, for example, there's no evidence that the donor's welfare was compromised by the decision-making or management of property by his attorney, or where there are no compelling allegations of malfeasance or wrongdoing on the part of the attorney. The courts have held that beneficiaries of a grantor's estate do not possess standing to compel an agent of the deceased under acting a power of attorney to pass his or her accounts. There is also case law. There's a body of case law that stands for the proposition that an estate trustee may step into the shoes of the incapable person after they've passed away in compelling a former attorney to pass their accounts. So the courts have held that while the Substitute Decisions Act contemplates the power of a competent donor to require his attorney to account, this requirement is intended to prevent abuse of authority by a negligent or dishonest attorney. Where the grantor was sui juris or capable during his lifetime, and the attorney made substantial but incomplete efforts to inform the beneficiaries following his death, the court has declined to order the attorney to provide a full accounting. So all of that to say, whether or not your client is ultimately successful in compelling this individual to pass their accounts, which essentially means prepare a full accounting showing the assets and liabilities of this individual when they began having involvement with the management of their finances, all money paid out during the period of their involvement, all money received, and what remained at the date of the order. Um, the ability of your client to compel this individual to provide such an accounting will depend on the facts and circumstances of their particular situation, including being able to establish whether your client has standing and has met the threshold to substantiate that they're a person who's in a position to seek such relief. Um, Now, if you're able to compel this individual to pass their accounts, there's many remedies within that application that may be available to your client in terms of clawing back funds that have been misappropriated. they have an ability to object to the accounts and seek repayment of funds back to the person who's been subject to the financial abuse. Beyond seeking to compel an accounting, as mentioned in the article that Peter spoke about at the start, that him and his colleague have written, um, there may be, in certain instances, it may be appropriate to sue the abuser for unjust enrichment, which would require that you establish that they were enriched, that the elderly family member suffered a deprivation, and that there was no juristic reason for that enrichment. And if you're able to demonstrate that, you may be able to obtain orders for repayment of funds or declaratory relief in terms of there being a constructive trust interest in the funds that the abuser took. Um, that's just a high level in terms of what some of your options might be in these situations. I hope it's been helpful. I'll finish my comments there, and I'll pass this over to Peter Neufeld, who will now discuss strategies to employ when a rogue caregiver is withholding access to an incapable person.
All right, thank you. I refer to you as Mr. Askew just so we don't confuse each other, but thanks, Peter, for that high level overview of dealing with an accounting and dealing with remedying financial abuse. As I mentioned before, what I want to talk about is, well, what happens if someone is a caregiver for the incapable person, this elderly person, their decision maker, and they are not facilitating access to family members and friends. In fact, they're obstructing. And I want you to consider a following example. Uh, that's not necessarily it's loosely fact based. Um, so it's 2022, and there are still serious concerns about COVID-19, although those concerns have decreased, but it's still very much in the zeitgeist. Uh, a lady, we'll call her Jackie, is the attorney for property and personal care for her mom, and she's been caring for her mom for the last 2 years throughout this pandemic, even living with her to do so. And rightly so, during that time, Jackie was restricting access to her mother um, to reduce the risk that she would contact COVID-19 and become seriously ill or even die. But now time has gone on, uh, and Jackie's brothers and sisters want to start seeing their mother again. Jackie, however, has other ideas. She continues to believe that COVID-19 is still serious enough that other family members should not be visiting her mother at all. At the same time, Jackie's siblings are in the dark about their mother's care. They don't know how, if at all, their mother has received any vaccinations. They don't know the state of her cognition. Time has gone on. Perhaps Jackie's mom is in her 90s. They don't know whether she's able to socialize with anyone other than Jackie. Uh, this isolation might also signify that Jackie could be unduly influencing her mother or otherwise taking advantage of her. And the problem here is there is a lot of unknowns, as I mentioned. Perhaps Jackie is doing a great job at keeping her mother alive, keeping her healthy, um, providing her the medication she needs, taking her to medical appointments, consulting with those professionals. But the problem is that she is still likely being overprotective to the point that it is detrimentally impacting her mom's relationship with other family members and friends. Now, I raise this, again, loosely fact-based scenario because it's something that, in my view, litigators have seen more so and continue to see and have used the pandemic as a justification well after it was justified. Siblings, particularly throughout the pandemic, were rightly so concerned about their parents' health and the state of long-term care homes. And for that reason, they chose to live and care for their parents and grew accustomed to restricting access to their parents for the sake of health. So now, when there is no longer that concern, how does a non-caregiver sibling address this issue when their other sibling is restricting access to their mother or father. I think first off, it's important to note that the conduct what I've described could very well likely be a breach of the Substitute Decisions Act. Section 66 of the Substitute Decisions Act indicates that the powers and duties of a guardian of the person shall be exercised and performed diligently and in good faith. And when I say guardian, I also mean a power of attorney, because that would be, in this case, a power of attorney for personal care, because Section 67 of the Substitute Decisions Act says that, with a few exceptions, everything in Section 66 also applies to attorneys. We also know from Section 66 of the Substitute Decisions Act that the guardian is required to foster regular personal contact between the incapable person and their supportive family members and friends of the incapable person. That's pretty clear. The guardian or attorney shall also consult from time to time with those supportive family members, with those friends of the incapable person who are in regular contact with them, and the persons from who the incapable person receives personal care. So professionals actually providing care to that individual. Now, as far as addressing this discrete issue, I would say that there's largely two avenues that a litigant can take, and they can take them separately or they can take them at the same time. Of course, when I say this, this is assuming that the powers of attorney are valid. You are not seeking to declare that the powers of attorney are invalid. You're seeking to, however, you're seeking to potentially terminate them on the basis that we're dealing with this rogue caregiver that's not looking after the best interests of the incapable person, and that they've engaged in conduct, which Mr. Askew briefly discussed, that warrants their removal. Now, in the article that we prepared, there is a decision that's kind of similar to here. It's the Pettipas versus Pettipas decision. That's Pettipas. And in that case, among other things, the rogue caregiver, we'll call her, was restricting access to the incapable person and was partly justifying those restrictions as a result of COVID, was saying that those restrictions were done on the result of medical advice and information gleaned through the media. However, there were competing arguments to say that this incapable person was just simply left alone without any care during the time that the rogue caregiver had obtained the powers of attorney. And in that case, the court found that the attorney was not fostering regular personal conduct as required by Section 66 of the Substitute Decisions Act. The evidence, including the fact that the attorney's sister was excluded from the assisted living home where the incapable person was living, demonstrated that the attorney was attempting to exclude her sister from having a meaningful role in their mother's life. And in this case, they did seek the successful removal of this attorney. Now, once you just remove an attorney, that's not the end of the situation. Of course, there has to be someone to act as a guardian of either as person or property, depending on whether the power of attorney for property was revoked or the power of attorney for personal care was revoked. And as Mr. Askew mentioned, this is not to be taken lightly. It is an onerous process. Very generally speaking, the process is prescribed in Part 3 of the Substitute Decisions Act to be appointed as a guardian. You need to, if you're dealing with property, you need to have a management plan prepared. If you're trying to seek the guardianship of the person, so to deal with their healthcare, you need to have a guardianship plan versus property, which is the management plan. Before all of that, you need to, or before actually receiving guardianship, there needs to be a declaration that the person is actually incapable of either managing their property or personal care, because there is a presumption in the Substitute Decisions Act that you have capacity. So we need a declaration from the court saying that you don't. Even before that, you may need to have what's called Section 3 counsel appointed, and we've discussed that in previous seminars, but effectively it is a lawyer that is appointed through the PGT by court order to act as the incapable person's lawyer, even if that incapable person does not have the capacity to retain them. And then they have to go through a process of still trying to secure instructions from them, and to the extent that they can, they are to advance those incapable wishes of those wishes of the incapable person to the court. This goes on for typically several months. It takes time, and the end result is that, of course, hopefully, if you're successful, you're appointed as the guardian of this incapable person, either guardian of the person or property or both. The problem with that presents is a practical issue. And the practical issue is that not everyone has the time to be appointed as someone's decision maker. You may love your mother or your father. That doesn't necessarily mean that you have the wherewithal, the time to actually accept an appointment to care for them, or at least to make decisions with respect to their property and personal care. And that brings me to my second avenue that you can seek, either separately or in conjunction. And that is directions under the Substitute Decisions Act. Section 68 of the Substitute Decisions Act states that if an incapable person has a guardian of the person or an attorney under a power of attorney for personal care, the court may give directions on any question arising in the guardianship or under the power of attorney. So this is a powerful remedy. The situation is that even if you are not replacing a power of attorney or an attorney for property or personal care, you can still seek directions to compel them to act within a certain framework if it is determined that they are breaching their duties under the Substitute Decisions Act. And like I mentioned, when a court is making directions on this, they will actually consider whether the attorney has complied with the Substitute Decisions Act. I talked a little bit about that, fostering regular personal contact, acting in the best interests of the incapable person, consulting with other family members and friends. If the court has found that they have not been doing that, then that may form a basis for a court to order directions to compel the attorney to do specific things. In this case, hopefully, the ideal situation would be seeking an order to facilitate unsupervised and unfettered access with the incapable person and their supportive family members and friends. A nice decision on that is the Lewicki and Baskus decision. That's 2024 ONSC 3715. And I was involved in that case, so I do want to note that it was divided success, but in this case, the alleged rogue caregiver in this case was found to have breached certain terms of the Substitute Decisions Act that compelled the court to order direction. So that is a nice case to look at the law of directions in this situation. There's also a strategic sense to getting these directions, because even if you are seeking to remove the attorney and replace them as the guardian of property and the person, seeking directions might be a good first avenue. One, because for altruistic reasons, hopefully, they will comply with that court order and it will obviate the need to replace them as a guardian. But strategically, if it's quite likely that they're not going to comply with that court order, you will be able to typically use their evidence of breaching that court order as a further basis to replace them and seek guardianship. And I say that because when you're dealing with whether someone has breached their duties under the Substitute Decisions Act, it's very fact specific. It's an inquiry that is going to take a lot of affidavit evidence for a court to consider, and there's going to be a lot of gray areas. What is less gray is whether someone has breached a court order for directions. And so this can be a strategic reason to still ultimately replace the individual as the authoritative decision maker. Um, there's also some situations in which the PGT can be appointed as the statutory guardian. If there is a risk of a serious illness or injury, deprivation of liberty, or personal security, then the PGT would be obliged to conduct an investigation to consider whether in fact, one or all of these situations exist. And if so, they would then be compelled to bring an application to be appointed as a temporary PGT for no more than 90 days. And there's pretty significant powers with this when they're conducting their investigation. They have powers under, I believe it's Section 82 and 83 of the Substitute Decisions Act, to enter premises, to get custodial orders with respect to the incapable person, even with the help of police, to access documents for the purposes of their investigation. And there's a nice overview of that procedure in a 2023 decision called PP versus Ashley Oliver and the Ontario Public Guardian and Trustee. And just if you're interested, that's the neutral citation for that is 2023 ONSC 5701 at paragraph 34. So I'll end it there. I think that's sort of a nice high level overview of potential remedies that you can consider when trying to get access for your client to see their mother and father who is where access is otherwise being obstructed. A similar situation is where that rogue caregiver is actually living with the incapable person, and that caregiver themselves refuses to leave the incapable person's property. And for that, I'm going to let Brad Phillips take on that topic.
Thanks, Peter. While none of the issues that we are reviewing today are simple, the issue of trying to effectively evict a caregiver from a parent's home, depending on the facts of the case, is, in my experience, the most challenging of the three scenarios. And while the paper touches upon some scenarios that can arise, excuse me, when an adult child remains in the parent's home after the parent passes, for the purposes of my talk today, I'm going to focus exclusively on scenarios where the parent is still alive and is living in the home with what I'll call the rogue. I certainly encourage you to review the paper in respect of some of the after-death issues that can arise. So I'm going to start with the scenario which is likely the most challenging, which is where the elderly parent remains in the house with the rogue adult child, and no determination has been made that the elder lacks capacity to make decisions for his or her care or finances. And I'm going to lay out a fact scenario to demonstrate the challenges involved. So let's say there are three adult siblings of an elderly father, two sisters and a brother. The brother lives with dad in their home and is named as attorney for property and care, and the dad has never been assessed for capacity at all. So the sisters are certain that their brother who lives in the house with dad is excluding them from access, but the emails and voicemails telling them not to come over, they aren't coming from the brother. They're coming from the dad directly. And the sisters have always had a good relationship with their dad. So these emails and voicemails are totally out of character. They are confident that the dad has diminished or no capacity, and that dad is being used basically as a puppet by their manipulative brother who lives in the house. So the words in those emails and in the voicemails are not really dad's at all. They're the brother's. And they want the brother out of the house so that dad can live in peace and have access to them. So typically in these cases, and as both Peters have referred to before, if you're retained by the sisters, you would bring an application for the removal of the brother as attorney for property and care, in order that he leave the premises, and likely in order that one or both of the sisters be appointed as the guardian of property or of the person for dad. But here's where it gets challenging. And as Peter Neufeld stated earlier, Ontario law assumes that adults are capable of making decisions until it's proven they are not capable. And that comes from Section 2 of the Substitute Decisions Act. So, as a condition of being appointed a guardian, the court must first be satisfied that the elderly adult actually lacks capacity. So, to address that issue, the application I just mentioned would typically also seek an order that the elderly parent be assessed for capacity to manage their finances and care, and seek a declaration that the parent lacks capacity. And that's where the real challenge lies, because even if the sisters are right in this scenario, that the dad is being manipulated by the rogue brother to exclude them and let him stay in the house, if dad has enough capacity to provide an affidavit that says, A, he doesn't want to be assessed for capacity, B, he wants the rogue brother to stay in the house, and C, he doesn't want to see his daughters because he's angry at them for whatever various and sundry reasons are given, this creates a number of legal challenges for the court. First is the issue about compelling the dad to be assessed. And there's a leading case from Justice Strathy in Abrams and Abrams, which will be posted in the chat. There's an important quote at paragraph 50, and it says as follows: in considering whether to order an assessment, whether on motion or on its own initiative, a court must balance the affected party's fundamental rights against the court's duty to protect the vulnerable. The appointment of an assessor to conduct what is essentially a psychiatric examination is a substantial intervention into the privacy and security of the individual. As Mr. Justice Patillo said, a capacity assessment is an intrusive and demeaning process. So, in the scenario I've just described, a court may in fact be quite reluctant to order that an assessment be done at all because they have a person who is presumed to have capacity coming before the court to say that they don't want a capacity assessment and they're happy with the status quo. So that doesn't, of course, mean that all hope is lost. But what it does mean is that practically, the sisters will have a very heavy evidentiary burden in a case like this, because they are going to have to present sufficient and compelling evidence of suspicious circumstances to overcome the court's general reluctance to order an assessment be done. Because they are going to essentially have to convince the court that there is real teeth to their assertion that dad is being used by their brother as a puppet, and that the words and statements he's made both previously and literally in his affidavit should essentially be ignored for their truth, but instead should be accepted as evidence that their father is being unduly influenced by their brother. And as I said, in my experience, that is a challenging evidentiary burden. But again, that doesn't mean all hope is lost. A 2022 case called Geffen and Geffen, Geffen, which will also be in the chat, provides some insight into what evidence might be necessary to have a court compel a capacity assessment in circumstances like this. So the background facts of that Geffen case are notably different than the one I've just described, but there are some parallels that I'll get to in a moment. In Geffen, an applicant's son was seeking to pass over the appointment of his 99-year-old mother to act as a state trustee over his father's estate, and instead he wanted to have he and his brother, who were named as alternate trustees, to act in this capacity. So here's the parallels. First, the basis for seeking this relief was because the applicant did not believe his mother had capacity to act as a state trustee, and he sought to compel her to be assessed by a qualified capacity assessor. In particular, the applicant brother was very concerned that his mother was being unduly influenced by his brother. And in that instance, in essence, if she was acting as a state trustee, she would really be controlled by whatever the rogue brother told her to do. So in this case, the mother was represented by legal counsel and she opposed being assessed. And notably, she'd previously had capacity assessments done 8 to 10 years earlier, but had not had any recent assessments. So in this case, it appears that the applicant had earlier been able to raise enough concerns about his mother's capacity and susceptibility to undue influence that the court on an earlier motion granted the applicant the right to have his mother be examined. And so the elderly mother's examination transcript and video was then reviewed and relied upon the judge on the motion seeking to compel a capacity assessment. And it's quite clear that the judge's review of this examination impacted on her views significantly. The judge did, in fact, order the assessment over the objections of the mother and distinguished the Abrams case that I just referred to earlier. Particularly, she noted that the mother had not been recently assessed, whereas in Abrams there had been other recent assessments conducted by qualified experts to do so, and therefore, in that case, the applicant was seeking a further recent capacity assessment be done, which was distinguishable. So turning back to the factual scenario that I described originally, what the Geffen case suggests is that you will likely need a compelling evidentiary foundation to support your claims that the rogue brother is manipulating the parent. That might mean you need to show that the brother has been actively involved in, for example, assisting the father to change his previous estate plans where there's been a marked change in favor of the rogue brothers. That might mean getting an expert to show that the emails sent to the sisters were not in the form or style of that dad had previously used, but is in fact more consistent with the wording of his brother. And if the dad did swear an affidavit, as was in the scenario I described, it suggests that his cross-examination may be very important to demonstrate to the court that there are in fact serious cognitive issues that warrant an assessment. And then again, you will also want to distinguish the Abrams case by noting that in previous cases, previous contemporaneous assessments had been undertaken and a further assessment was deemed to be too intrusive, whereas in this case, no previous assessment had occurred at all. Other factual scenarios discussed in the paper are quite different. And while still complicated, I would suggest they are less so than the scenario I just described, because in these other cases, it's often clear that the elderly parent does not have capacity to make decisions about their care or finances, and therefore won't be speaking to the court directly. And that is a big difference in my view. So, for example, if there's a case where a parent has already been moved out of the house and because they're in a long-term care home due to their needs, if an adult child is remaining in the home and despite the parent no longer living with them, there is a more straightforward argument to present that if you can present a compelling case to the court that the parents' financial needs necessitate that the house be sold in order to pay for their ongoing care needs in the long-term care home, that is something that a court will more likely than not entertain. Particularly if it's a scenario where the adult child living in the house is not the attorney for care and property. In that case, other family members could move to bring that type of application and seek their removal from the house in order to demonstrate that the financial needs of the parent necessitate that the house be sold. And one thing to consider is that, and as Peter referred to earlier, typically adults living with their parents aren't paying rent. So that doesn't fall within the definition of a tenant under the Residential Tenancies Act, which means that the relief you are seeking would be in the normal course, in the regular courts or the Superior Court of Justice. The type of scenario I just described being bringing an application or a motion to have an adult child removed from a house when a parent has already left the premises. You can see the Wadwani cases and the Buckler and Ernst decisions, which are in the paper. The slightly more complicated scenarios are where either the rogue child is the attorney for property and care. In that case, it may be necessary, as described before, to seek the attorney's removal and be appointed guardian in order to have the legal entitlement to then have the rogue child removed from the house. And a similar case on that point is the Petipus case, which I believe Peter referred to earlier, which is also in the paper. And then finally, another potentially more complicated scenario arises if, for example, the adult child who is staying in the house was at some point put on title jointly with the parent, and the parent now needs to live in a long-term care home. So on the one hand, the adult child may argue that the property was intended to be owned by them and therefore that shouldn't be sold and they shouldn't obviously be evicted as a result. On the other hand, because the property was likely transferred for nominal consideration, there is a presumption of resulting trust that arises when the adult child receives an asset from their parent for no consideration. So a court may conclude that the house was transferred jointly to reduce probate taxes for when the parent died. But that doesn't change the fact that in the now, the house needs to be sold now to assist with the parent's current care needs. And if there are funds left over from the sale of the house when the parent dies, then maybe the adult child might have a fight with the estate over the proceeds, but that may not be sufficient to prevent the sale of the property and obviously the eviction of the adult child. So that's it for my talk, and I'll pass it back to Peter.
Thank you very much, Brad. So now is the time we're going to open the floor to questions that people might have. You can ask them orally, or you're welcome to put it in the chat. I do see that we have one question, and I'll just raise that right now. The question is, when considering capacity assessments, what time is considered recent? 1, 2, 3 years, other? It's a good question. And the complication is that if there's a capacity assessment that someone has dementia, significant dementia, that is clearly impacting their capacity. Although a diagnosis of dementia is not on its face determinative of lacking capacity, it is very helpful evidence. And then the question is going to be, well, how recent does that report need to be? And I think that is a fact-specific situation. Often when I'm presented with that situation, if I have a capacity assessment or a medical diagnosis saying that someone has really severe dementia, it's often incumbent upon the litigator to, if they don't have any other evidence that's more recent, to persuade the judge that this is not a situation in where they will now regain cognition, that dementia is progressive. It typically gets worse over time. And I have found that often that may be sufficient to alleviate judges' concerns that assessment or that diagnosis may not be as recent as they would like it. Brad, do you have any thoughts on that?
I guess my thought would be a couple of things. One is, as Peter said, if there's already been a history of a diagnosis of dementia, then it's going to, that would suggest that things can change significantly over a short period of time. So I would again, it's obviously very fact dependent about this, but you would think that if 3 years passed or 2 or 3 years passed, there might be enough changes that a court may not view that as being quote unquote a recent assessment, and they would be convinced that perhaps a further assessment is warranted. The other scenario, I think, is it really depends on the age of the person. I suspect that if if they're well advanced and into their even 90s, a court may say the cognitive changes at that age could be really significant, and so it may be that 1 year isn't even deemed to be recent in that scenario. So I don't think there's a hard and fast rule. I think you have to factor in what the medical diagnosis is at the time the initial assessment was done and consider the age of the person.
Okay, very good. There's a few other questions here. One is, when a rogue child demands access, but there is evidence of that adult child abusing the incapable person, is there case law on either providing supervised visits or stopping visits? Also, if the POA of personal care is very concerned and has evidence, is there any way to keep the access very limited? I mean, my opinion on that would be that doesn't fall under the duties under the Substitute Decisions Act to foster a relationship with that individual. If there's evidence of abuse, then, depending on the strength of that evidence, I think there's a good argument to be made that they're not a supportive family member, and therefore there would not be that same obligation to foster a relationship with them and foster contact with them. Brad, do you have any further thoughts on that one?
No, I agree. That isn't a situation where, and that's a reverse situation where it appears that the rogue child is actually going to be the applicant seeking access. So I think Peter's comment that that in that case, relying upon the Substitute Decisions Act and the obligation to consult with supportive family members, the rogue child, if you can prove that he or she has a history of abuse, wouldn't meet that standard, and that the relief being sought by the rogue child could be resisted.
We've got a question that's more about an obligation of a solicitor. So this question is, what are your professional obligations when you are dad's long-term solicitor and his children come to you for help regarding a rogue sibling? Does your answer change whether you did or did not prepare the power of attorney in favor of the rogue child? I mean, I think to me, immediately the question would be for me as well, is there a potential conflict of interest here? And I'm not saying that there is or isn't, but I think that's something that you would really need to concern yourself with as to before you give advice to anyone else other than the father, you really do need to concern whether there is a conflict of interest that precludes you from giving certain advice. Because even if the father is incapable, I mean, the privilege between the father and that solicitor would certainly still exist. And so I would say that, yeah, it could change on whether or not you prepared the power of attorney. Certainly, I think it would if they're going to be taking arguments to say that that power of attorney is now invalid because the dad didn't have capacity. But even if that doesn't exist, I'd be concerned that there might be conflict of interest issues there. Brad, anything to add to that?
Yeah, I would agree with everything Peter said. And in terms of the issue about if you were actually preparing the power of attorney, more than likely you're going to potentially be a witness. So in that case, the conflict becomes quite apparent that you would be potentially precluded from acting in any event. No, excuse me.
Peter, if I may. Peter?
Yep.
I'm just going to put something on the chat, and I'd like to raise it for a discussion for the three presenters. What I did is I attached the Ontario Regulation 100/96, and I'm afraid that in my experience, it's not as known to as many lawyers as it should be. And I'm wondering, have you ever used this reg to your advantage when you're trying to compel disclosure and especially when it comes to the confidentiality and disclosure of the accounts and records, because it indicates what the responsibilities are on a more minute level.
Yeah, so it's a good question, and I know that we refer to this regulation in the paper. Often what happens when you're dealing with an accounting is you first seek relief for an informal accounting. You see what you get from that informal accounting, and then you try to justify to say that we need a formal passing of accounts. The problem is that the informal accounting does not need to be in accordance with this regulation, but a formal accounting would. So I've used this regulation. I can't say whether I've used the regulation to say that, okay, we have this informal accounting, but it doesn't address X, Y, and Z. And if it was actually formal and it was in accordance with this regulation, we would have that disclosure that we need. It's a good argument to make. What I've typically used this for is to provide a notice of objection to when I receive a formal application to pass accounts. We put in our notice of objection to say all this information that you should have included was not provided.
I've used it even in case conferences to outline the obligation that the attorney has to keep certain records. And if my client falls within the gamut of one of the powers, one of the attorneys for property that's seeking production from the other, that there's a statutory obligation for them to disclose the accounts. And I think that can be used, and I've used it, certainly in negotiations and leverage. And I think that what's not known is that there's also an obligation for a guardian of person to keep records of decisions. So when they want to exclude concerned family and friends, and the information from co-attorneys, again, they have an obligation to keep certain records and disclose it. And I think it's useful, good arrow for people's quiver to have in hand. So if anybody wants it, there's a link on the chat.
I agree. Thanks very much, Charles, for that. So it's 1:03 right now. I want to respect everyone's time. So we're going to end the seminar for today. Thank you for everyone who was here, who attended the seminar, and especially to those who asked some questions at the end. I'm sorry for those that asked questions that we couldn't get to. Please remember that the certificate of attendance is found in the chat. We're looking forward to seeing you at our next seminar about settlements involving the incapable person, which typically need court approval. That's going to be on September 30th, and it will be chaired by Alex Prokop, Jake Pallas, and Brendan Donovan. If you haven't registered for that one, you can do so at the link posted in the chat. And again, as a final reminder, the link to the B'nai B'rith to make a donation can also be found in the chat in the case that you'd like to make a contribution. Thank you again. Have a wonderful rest of your week.